Right now, if you are a green card holder, a visa applicant, or someone waiting on an immigration benefit from USCIS, what I'm about to tell you could directly affect your case. Not in theory, not someday. Right now, in 2026, there are new policies in place, new enforcement priorities, and new scrutiny being applied to permanent residents that most people in the immigration community are not fully aware of. The rules around travel, public charge, status review, and processing have all shifted in ways that are not getting enough attention. If you travel internationally on a green card and you don't know what changed, you could face secondary inspection. If you received any government benefits and you don't know what's being evaluated, your naturalization could be at risk. And if you're waiting on a pending case and you don't understand how the new vetting frameworks work, you may be waiting far longer than you expected. Stay with me, because the next 12 minutes could be the most important immigration update you watch this year. My name is Raymond Crivello. I'm a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. I don't traffic in rumors. I don't amplify fear. What I do is take the actual policy, the memos, the regulations, the court orders, the visa bulletins, and translate them into information you can use to make informed decisions about your immigration journey. Before we go any further, I want to be clear. I am not your attorney, and this content is for educational and informational purposes only. Immigration law is complex and highly fact-specific. Always consult with a licensed immigration attorney about your specific case. Now, let's get into what is actually happening. Let's start with the big picture. Beginning in early 2025 and accelerating through 2026, the Trump administration has implemented a series of overlapping immigration enforcement and policy changes that collectively represent one of the most significant shifts in immigration governance in decades. These changes have come through several channels: executive orders issued directly from the White House, policy memorandums published by USCIS and DHS, new vetting protocols issued by the State Department, and regulatory guidance that has altered how adjudicators evaluate cases. Who made these decisions? The authority flows from the President through the Department of Homeland Security, which oversees USCIS and CBP. The Secretary of DHS has broad administrative authority under the Immigration and Nationality Act, the INA, to direct enforcement priorities and adjudication standards. Now let's talk about what specifically changed. There are 4 major areas every green card holder needs to understand. Area 1. Enhanced vetting for nationals of high-risk countries. USCIS has implemented new vetting protocols for applicants and current permanent residents from countries designated as presenting elevated national security concerns. This means I-485 adjustment of status applications, I-130 petition approvals, and even naturalization N-400 applications from individuals born in certain countries are being subjected to additional scrutiny, longer processing times, and in some cases, interview requirements that weren't previously standard. Area 2. Expanded public charge rules. This is something many people are underestimating. The Trump administration has significantly expanded the definition and application of the public charge ground of inadmissibility. Under the new framework, any use of certain public benefits, including Medicaid in some circumstances, housing assistance, and food assistance, is being weighed more heavily during green card applications and renewals. But here's where this becomes critical, and where many green card holders are making a dangerous mistake. The enhanced public charge review is not limited to new applicants. It's also being applied to people filing for naturalization. If you received public benefits after becoming a permanent resident, and you are now filing your N-400, adjudicators may flag that history. I'm not saying it will automatically disqualify you, but it is being scrutinized in ways it wasn't before. Area 3. Green card travel scrutiny. This one is directly affecting permanent residents right now, today. CBP, Customs and Border Protection, has been directed to apply enhanced scrutiny to green card holders returning from international travel, particularly those who have spent extended time abroad or who are traveling from specific countries. There are 2 critical thresholds you must know. If you leave the United States for more than 6 months at a time, your green card can be presumed abandoned. If you leave for more than 1 year, your green card is generally considered abandoned unless you obtained a re-entry permit before leaving. These rules are not new, but what is new is the level of enforcement. CBP officers are exercising that authority more frequently and more aggressively than they were even 18 months ago. Area 4. Processing delays and case freezes. USCIS processing times across the board have extended significantly in 2026. The combination of increased vetting requirements, staffing reallocation toward enforcement, and policy changes requiring re-adjudication of certain categories has created a backlog that is affecting family-based cases, employment-based cases, and humanitarian categories alike. Now I know you're thinking, this applies to people who are doing something wrong, right? It's only people trying to abuse the system. Let me stop you there. This is what many green card applicants and even established permanent residents are fundamentally misunderstanding about the current environment. These policies are not surgical, they are broad, and the people getting caught in them are largely individuals who have done nothing wrong, but who simply weren't aware of the updated rules, or who made travel or financial decisions under the old framework. There is one detail most people are completely missing, and it could cost you months of processing time or worse. The new vetting protocols apply retroactively in their review window. This means that when USCIS adjudicates your case today, they are looking back at your history, not just what you did last month, your full immigration history, your travel history, your benefit history, your country of origin. This could affect you even if you are not in one of the high-risk country designations. Secondary scrutiny is now being applied more broadly at the discretion of individual officers. Let me make this real for you. Let me tell you about a hypothetical family, a family that represents thousands of real situations happening right now. Consider a family we'll call the Hernandezes. The father, Carlos, became a permanent resident 6 years ago through an employer-sponsored green card. His wife, Maria, has been waiting on an I-130 family-based petition for 4 years. Their daughter is a U.S. citizen. They've followed every rule. They've filed every form. They have never had a legal issue. In 2024, Carlos traveled back to his home country for 3 months to care for a sick parent. He was gone for 92 days. Under the old enforcement environment, no issue. Under the current environment, his return triggered a secondary inspection. He was asked detailed questions about his intent to abandon residency. He was held for 2.5 hours. Eventually, he was admitted, but his case was flagged. And now, when Maria's I-130 comes up for interview, that flag is part of the file. Meanwhile, Maria's case has been pending since 2022. The family-based F2A category, spouses and children of permanent residents, has experienced significant movement in the visa bulletin, but actual interview scheduling at their consulate has been delayed by months due to what the State Department calls additional administrative processing. Carlos and Maria did nothing wrong. They are exactly the kind of family the immigration system is supposed to serve. But because they didn't know the rules had changed because they weren't monitoring the policy updates, they are now navigating a situation that is far more complicated than it needed to be. Don't be the Hernandez family. Know the rules before they affect you. So what do? Here is a structured 5-step action plan for every green card holder right now. Step 1. Audit your travel history immediately. Pull every entry and exit stamp from your passport for the past 3 years. Calculate the number of days you spent outside the United States in each trip and cumulatively per year. If any single trip exceeded 6 months, or if your cumulative time abroad per year is approaching or exceeding 6 months on average, consult an immigration attorney before your next international trip. Do not guess on this. Step 2. Review your benefits history carefully. If you or any member of your household has received public benefits since you became a permanent resident, including Medicaid, SNAP, housing assistance, or certain federal programs, document the dates, the amounts, and the circumstances. If you are planning to file for naturalization or for adjustment of status for a family member, discuss this history with a licensed attorney before filing. Do not assume it won't come up. Assume it will and be prepared. Step 3. Monitor USCIS and State Department updates consistently. The USCIS Policy Manual is a living document. Policy alerts are issued without press releases or major media coverage. The Visa Bulletin moves every month and the movement has been volatile in 2026. Bookmark USCIS.gov and travel.state.gov. Check them monthly. Check this channel for analysis. Staying informed is not optional in this environment. It is a protective strategy. Step 4. Protect yourself from immigration fraud. In periods of policy uncertainty and fear, immigration scams proliferate. Notarios, consultants who claim to have special access to USCIS, websites that charge fees for free government forms, anyone who guarantees you a green card or promises to fix a complicated case for a flat fee with no attorney involvement. These are predators. The only person who can give you legal advice about your specific immigration case is a licensed immigration attorney or an accredited representative through a recognized organization. Be careful, be skeptical, ask for credentials. Step 5. Consult a licensed immigration attorney before making any major moves. Before you travel internationally for more than a month, before you accept any public benefit, before you file any new application with USCIS, before you respond to any request for evidence or notice of intent to deny, consult an attorney. The cost of a consultation is far less than the cost of a denied application or a revoked status. Now let's zoom out, because I want you to understand not just what's happening now, but what's coming next, and how certain or uncertain any of this actually is. The current policies are a combination of executive action and regulatory guidance. They did not require congressional approval to implement, which means they can also be modified, reversed, or further expanded by the executive branch without going through the full legislative process. This is important. It means the situation could change. However, it also means that legal challenges are possible and some are already underway. Several of the enhanced vetting and public charge policies have faced or are currently facing federal court challenges. Depending on how courts rule, particularly at the circuit court level and potentially at the Supreme Court, some of these policies could be paused, modified, or vacated entirely. However, this protection may not be permanent. Even if a court issues a preliminary injunction blocking a specific policy, that ruling can be appealed. And during the appeal process, enforcement practices often continue in modified form. Do not plan your immigration strategy around the assumption that a court will save you. Plan based on the rules as they exist today. On the congressional side, there are proposals circulating to codify some of these changes into statute. If that happens, these policies would become significantly harder to reverse through executive action or litigation. As of the recording of this video, no comprehensive immigration legislation has passed both chambers, but the legislative environment is active, and that could change. My realistic timeline assessment, the enhanced vetting protocols and expanded public charge rules are likely to remain in place through at least the remainder of this administration. Processing delays may ease somewhat as USCIS adjusts staffing, but the structural backlog will take years to resolve. Travel scrutiny at the border is policy-driven and unlikely to relax in the near term. I want to close this section by stepping back from the policy and speaking to what's actually at stake here. Immigration status is not a bureaucratic inconvenience. It is the foundation of your life in this country. Your immigration status affects whether your family can be together. It affects your ability to work, to build a career, to advance professionally. It affects your financial stability, your ability to buy a home, to access credit, to build something lasting. It determines your path to permanent residency and eventually to citizenship. When immigration policy shifts, the human cost is real. It shows up in families separated by processing delays, in professionals who can't travel for work, in people who made legal decisions based on rules that were in place at the time, and who now find themselves in a changed environment with consequences they didn't anticipate. That is not a reason to panic. It is a reason to be informed. It is a reason to take this seriously. It is a reason to have a plan. You deserve accurate information. You deserve analysis that treats you as an intelligent adult capable of handling the truth. That is what this channel is here to provide. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Drop your visa category or your country of origin in the comments below. I read every single one, and your comments help me understand what topics matter most to this community. If this video helped you, share it with someone who needs this information. And if you found this analysis valuable, give it a like. It helps factual immigration coverage reach more people who need it. I'll see you in the next one.